has said, we had to negotiate this brick by brick with Council and Commission to get the main planks of this report in place, particularly the delegated acts for the Union list and what can be added to the list, and also for the very important Commission declaration on pesticides, and we've talked about it over and over again, gluten. Just to answer Mr. Rossi, who I can't see anymore, and my Italian colleagues who spoke up on this matter, of course he's right to recollect that the final compromise that we're going to put to the vote soon does not incorporate Parliament's first reading position entirely, including these gluten-free products in the scope of the regulation. I know how spiny, how thorny this issue was. It relates to 1 European in 300, and in Italy it sounds like the figures are even higher. 1 in 100 was the figure that Mrs. Gardini mentioned. In Italy the situation may be particularly different. There's a reimbursement issue that applies to gluten. The compromise that has been wrapped up in the trialogue is an acceptable compromise for all the negotiators, and it's also acceptable, and I'd like to remind you of this, to all the organisations that contacted us, including the European Umbrella Association representing celiac patients. On behalf of all my shadows, I'd like to mention Mrs. Caterina Pilu, the President of the Italian Celiac Association, has congratulated us, so I would say to Mr. Rossi that I think he can put his mind at rest with respect to the text we're going to vote on later. And I'd like to thank all those who've worked on it throughout the negotiations for that, and of course I hope they'll all turn out to support it in the vote this afternoon.
Thank you. Colleagues, that brings us to the end of our debate. May I remind you that the vote on Ms. Rees's report will be taken in session starting at 11:30 today. Our next item is a Commission statement on US Internet surveillance on European citizens, the NSA's PRISM programme. I would like to inform you, colleagues, that during this debate there will be a round of speakers on behalf of the various political groups, that we will not have the catch the eye procedure, nor will you be able to use your blue cards. I will now give the floor to Commissioner Borg.
Yes, Madam President, thank you. I am reading this statement on behalf of the Commission, and I'm here today instead of Vice President Reding, who is unavoidably absent. The European Commission is concerned about recent media reports that United States authorities are accessing and processing on a large scale the data of European Union citizens using major US online service providers. Programmes such as the so-called PRISM and the laws on the basis of which such programmes are authorised potentially endanger the fundamental right to privacy and to data protection of EU citizens. The PRISM case, as reported in the media, is also likely to reinforce the concerns of EU citizens regarding the use of their personal data online and in the cloud. Already in 2012, 70% of EU citizens were concerned that their personal data held by companies could be used for a purpose other than the one for which it was collected. The PRISM case, as reported in the media, also highlights the difference between the European Union and the United States approaches to data protection. Whereas in the US legal system, only US citizens and residents benefit from constitutional safeguards, in the European Union, everyone's personal data and the confidentiality of their communications are recognised and protected as fundamental rights, irrespective of their nationality. While reports are particularly worrisome, the legal issue at hand is not a new one. It has been tackled by the Commission in the past. To give a single example, the Commission has already raised the matter of law enforcement access to personal data of European citizens in the framework of the ongoing negotiations with the United States for a general data protection agreement in the field of police and judicial cooperation. As you know very well, Vice President Reding has received a mandate to negotiate this agreement with the United States, and she is keeping this House, and in particular members of the LIBE Committee, informed about the progress of these negotiations. The Commission is asking for clear commitments from the United States as to the respect of the fundamental right of EU citizens to data protection and as to access to judicial redress in the same way as it is afforded to United States residents. As far as the PRISM programme is concerned, the Commission will raise this matter with United States authorities at the earliest possible opportunity. It will request clarifications as to whether access to personal data within the framework of the PRISM programme is limited to individual cases and based on concrete suspicions, or if it allows bulk transfers of data. Vice President Reding will raise this issue with force and determination at the upcoming EU-US Ministerial on Friday in Dublin. Beyond contacts with the United States, the European Union can also act by making sure that it equips itself with robust legislation able to confront such situations, and I refer in particular to data protection. Under the current EU legislation, the 1995 Data Protection Directive, when the rights of a EU citizen in a member state are concerned, it is for the national judge to determine whether the data can be lawfully transmitted in accordance with legal requirements, be they national, European or international. The Commission believes that these concerns need to be further addressed. This is the aim of the proposed General Data Protection Regulation. The reform proposed by Vice President Reding maintains the current high level of data protection in the EU by updating citizens' rights, guaranteeing they know when their privacy has been violated, and making sure that when their consent is required, the consent is real. More specifically, the EU data protection reform should ensure that the European Union is able to tackle situations such as the PRISM programme through its data protection rules with a clear provision on territorial scope. Non-European companies, when offering goods and services to European consumers, will have to apply the EU data protection law in full, a broad definition of personal data, clear responsibilities for processors, and strong rules for international transfers. Recital 90 of the proposed General Protection Regulation reflects our view that in order to avoid conflicts of jurisdiction, access by third country law enforcement authorities to the personal data of EU citizens held on the servers of US companies should be done via established legal channels such as the EU-US Mutual Legal Assistance Agreements. The European Parliament has submitted amendments to further clarify in the provisions of the regulation the conditions under which the judgment of a court or a tribunal of a third country is enforceable under EU law. The Commission will look at these proposals. Honourable Members, Madam President, the Commission believes that the quick adoption of this proposal would resolve any legal loopholes created when companies collect and handle personal data of European citizens and face two different sovereigns. The Commission therefore counts on this Parliament to support the objectives and principles of the EU data protection reform and work on a swift adoption of the package. Thank you very much.
Thank you very much, Commissioner Borg. And now the speakers on behalf of the political groups. And first I would like to give the floor to colleague Weber on behalf of the PPE for 4 minutes.
Madam President, Commissioner, my data belong to me. That is a cornerstone of European thinking on data protection. The state also recognises that my data belongs to me. I decide what happens with it. That principle must be respected by the state. Those boundaries must be taken seriously. Reports from the US are cause for great concern. It is good that we are discussing the matters here today. It is good that debate has been triggered in the US. We need to look at the right way to handle personal data. It is completely unacceptable, and I would like to make that clear on behalf of the EPP, it is completely unacceptable that the United States of America has different rules governing access to personal data applicable to US citizens on the one hand and citizens of other countries on the other hand. Our friends in the US should know that. We now need to define our targets, our objectives. First and foremost, we need transparency. We need to know what is going on. Vice President Reding and the Commission as a whole has the full support of the European Parliament when she calls for clarity in Dublin. We need to look at implementation of existing rules. We want transparency from companies. If Google, Facebook and other companies active in the US work in Europe, then their customers need clarity. Is access being provided to this data or not? What about the UK? There are reports that the UK Secret Services are allowing access to the data of European citizens. We need clarity from the British government. Fourthly, the internet is a global phenomenon. We need common standards, joint standards. The Commission is working on a framework agreement for police and judicial cooperation. This is good. This is something we welcome. Perhaps we also need a framework agreement on private data. We need global state standards agreed with the US. That is something that we should work towards, a framework agreement for personal data. We need a European cloud. If European data is to be stored in the cloud, it should be held in Europe. Then we can guarantee to our companies and citizens that this data is being stored and secured according to European standards. Sixth point, we need modern EU data protection legislation. We cannot call our US friends to order if we do not have the highest, most modern standards implemented here in Europe. There are developments that I have concerns about as regards the quantity of data being stored. We need to look at the technology to analyse this data. Where progress is made, we must be brave enough to set clear limits and standards along the lines of what the Commission has proposed. On the 9th of July, we will be voting in the committee. We cannot leave ourselves open to blame. We cannot hesitate. I would call on the Council to stop focusing on the minor points of detail and really look at the major challenges being faced today and come up with the results. Finally, it is important for the EPP today that we reiterate that the US is our partner. We were not in a position to build up standards when it came to SWIFT, the fight against international terrorism, organised crime. European authorities, however, did benefit from the analysis carried out. A bomb attack was prevented in Germany because we had been tipped off by the US authorities. A second Madrid was prevented. So I would like to reiterate loud and clear that the US is our partner. When it comes to SWIFT, we're still waiting from the Commission to come forward with a European proposal for a European system to analyse financial transactions. Now, the US approach is not our approach, but we work together as partners to achieve our common goals. Thank you very much, Madam President.
Thank you very much, colleague Weber. And now, colleague Moraes, on behalf of the S&D Group, for 4 minutes.
Madam President, Commissioner, for the S&D Group, the events of the last few days, the information published by The Guardian last week with regard to the top-secret US system of surveillance called PRISM, enacted by the NSA, allegedly in cooperation with IT world giants like Apple, Facebook, Google, Microsoft, Skype, YouTube and AOL, trusted major giant companies, have caused shock to our European citizens. And for the S&D Group, we are very clear that while security is important, this has caused, for our citizens, a major breach of trust. And for us in the S&D Group, the ministerial meeting on the 13th and 14th of June is something that we regard as vitally important, that the Parliament, that all the political groups give the Commissioner support in holding to account Eric Holder, the United States, for what they have done in transferring allegedly bulk information of our citizens, which may be completely unnecessary in the fight against terrorism, in the fight for security of our citizens. Unnecessary information which then breaches trust in the way that data is secured and in the fight against terrorism and the fight to maintain security. It's that balance between security and the need to protect data, that vital balance. The reports in The Guardian, The Washington Post and New York Times seem to show that these companies, required by the NSA to share information for anti-terrorism purposes under the FISA and upon secret FISA court orders, accepted to do so and facilitated access to their servers to US intelligence agencies, possibly offering the US intelligence community the possibility to send queries directly to company-managed secure online rooms. We are particularly concerned that generalised access to and mass processing of EU citizens' data for law enforcement or other purposes may have taken place under the responsibility of the above-mentioned companies in the framework of this programme in a way that is non-compliant with EU data protection legislation in force. We are also worried by the absence of an overall transatlantic legal framework ensuring the protection of personal data, especially considering that negotiations on an umbrella data protection agreement between the EU and the US are ongoing since 2011, but seem to have been currently stalled. For all of these reasons, we wish to ensure that the Commissioner holds to account the US and to ensure that US public authorities, that when they are processing US citizens' data, do so within our standards. Secondly, we wish to reaffirm our commitment to a high-level agreement on the proposed data protection reform package along the lines defined originally in our proposals and reinforced by amendments tabled by the EP rapporteurs and shadows improving protection requirements. In this context, we deem it quite clear that our EU legal framework for data protection for law enforcement and security purposes by public and private actors remains extremely relevant and cannot in any way be delayed. And finally, we believe that a special attention to issues related to data protection and data flows will be required while negotiating the important EU-US TTIP agreement in order to safeguard the maintenance of primary EU legislation in this field. We are well aware of the commitment of the Commission to hold the US to account in relation to data flows, but it is extremely important in the light of the PRISM and NSA issue that EU citizens are assured of what can happen. In my own member state, the United Kingdom, there is serious concern as to what has happened, and trust has clearly been breached. It's up now to the EU to play its role in ensuring that we hold to account what the United States has done in this case, that our standards are maintained and that EU citizens are assured that the right standards are maintained.
Thank you very much, colleague Moraes. Colleagues, let me remind you that according to the decision of the political groups, there is no procedure of catch the eye or blue cards in this debate, and that was in order to secure more time for the speakers of the political groups. And now I would kindly ask colleague Intveld on behalf of the ALDE to take the floor for 3 minutes.
Thank you, Chair. Colleagues, Commissioner, 500 million European citizens were very shocked last week to find that a foreign nation has unlimited access to every intimate detail of their private lives. This is a very, very big issue. In the United States, this is considered to be Chefsache, as the Germans say. It was the President himself who came and answered to questions of Congress and the media. So, what do they see in Europe? First of all, with all due respect to the Commissioner, we get the Commissioner for Public Health to deal with this issue, while President Barroso, who should have stepped in his helicopter and flown to Strasbourg to answer to 500 million citizens, we have at least the responsible Commissioner for counterterrorism in the House. Where is the responsible Commissioner? Why aren't the prime political leaders of Europe here? But we also need to look at ourselves, colleagues. Look around you. An empty hemicycle. This House, just over a decade ago, when faced with a similar situation, something called Echelon, we decided to set up a heavy parliamentary inquiry into Echelon. Today we get a handful of dedicated MEPs to address 500 million citizens. We are failing the European citizens at a time where trust in the European Union is at an all-time low. We should be ashamed of ourselves. And then, to the subject matter itself. First of all, we can't have been very surprised to find that the Americans are spying on us, because we knew about it. We have been asking questions again and again and again. But asking questions to the Commission is like talking to a wall. I have a long list of non-answers to my questions about FISA, about the Patriot Act, about extraterritorial application of US law, and we get no answers from the European Commission. The Member States, because there is a national debate about the same issue everywhere now. Mrs. Merkel will ask the Americans for an explanation. But in all our member states, including the UK, Mr. Moraes, and in my member state, we are doing the same. So the member states are speaking double-speak to the citizens. Are we surprised that they are losing trust? And actually, you can say that the citizens don't trust their governments anymore, but the governments seem to trust their citizens even less. We are also losing moral authority here. How can we tell the governments of, say, Egypt, Iran, any other country, that they should not spy on their citizens because that has no place in a democracy? If we are doing the same on our citizens, we are losing credibility here. On the special relationship, I have heard nearly all colleagues here refer to the special relationship with our best friends and closest ally, the United States. Well, I don't know if you listened to the statement of President Obama when he was addressing the American audience who were worried. He said, don't worry, we're not spying on US citizens, we're only spying on foreigners. Foreigners. So that's us. That's European citizens. So what kind of a special relationship is that? And over the last 12 years, Europe has bent over backwards to be the closest ally of the Americans in the fight against terrorism. And I'm sure that we will continue to be their ally. But then we need to see eye to eye. And we expect the Commission, and with all due respect, I'm grateful you're here, Commissioner Borg, but this is Chefsache. This is a matter for political leadership. We need political leadership in Europe to defend the rights of our citizens. And the time is now.
Thank you, colleague Intveld. And now we'll give the floor to colleague Albrecht on behalf of the Greens for 1.5 minutes.
Thank you very much, Chair. Dear colleagues, dear Commissioner, I completely share the concerns which have been raised by all political groups here, and I would like to say that it's not only data protection, it's not only a small technical issue. This is about the rule of law and about democracy, because both of them are not in line with mass surveillance. They cannot be in line with mass surveillance of citizens, of people all around the world. And so we need to stand up here to say clearly mass surveillance is not what we want to have, and we need strong data protection rules. We need it as a precondition for democracy, for rule of law, and also for security and trust in the digital market or in the market as a whole. So therefore it's a very good issue that we react as Europeans with creating our own standards on data protection, safeguarding the rights of our citizens in the first place, and decide as quickly as possible on the proposed regulation on data protection with strong standards, also with regard to third state transfers, because this is about companies processing personal data, masses of personal data of us, and then giving the opportunity to third states authorities to access them. If we really want to have a safe European cloud, we need to make sure that we have strict and strong EU data protection rules, which are then also enforceable and which create clear rules for third state transfers. Only that will help, and as a rapporteur for the framework agreement on data protection with the US, I really say I would like to work on it and I would like to agree on standards with the United States, but therefore we need movement on the other side of the Atlantic. We need some legislation, we need some legislative changes, because without legislative changes we will not come to a common basis. Thank you very much.
Thank you very much also. Θα δώσω τώρα το λόγο στον συνάδελφο Kirkhope από το...
Thank you. I'll give the floor now to our colleague Mr. Kirkhope for 3 minutes.
Mr. Commissioner, the debate here today is about increasing the trust and faith of citizens in holding to account governments and agencies that serve and protect them. Those companies already named and shamed have so far denied acting outside the law. Governments and the European Commission have expressed concern, we've heard this morning, but rightly acknowledge that it is currently too early to draw final conclusions. Yet here we are, already pointing the finger, some of you already expressing strong anti-American or anti-Commission rhetoric that is all too familiar, as is the opportunism and grandstanding without pausing to gather facts or proof. But of course this plenary is no stranger in the practice of convicting a defendant before the trial. This Parliament is currently working hard on reforming its data protection rules and is still pursuing agreement on data exchange with the United States, something which I and my group support. Key to the success of being able to protect our citizens beyond our own borders is our relationship with other countries. Yet I would caution that often the way in which some members of this House articulate themselves does little to bring us together on values, but instead pushes us further apart. Protecting citizens from modern threats is a balancing act. Intelligence agencies are often lambasted for not acting soon enough, and then equally condemned for going too far. Their successes are celebrated in private, but their failings are only too public. Increasingly, as we know, terrorists and organised criminal groups use information and technology against innocent citizens. Therefore, there must be an expectation that the same technology will be used in our response. But that information must, of course, be used and respected within the confines of democratic principles and legal oversight. We must understand that we do not gain more freedoms by taking others away, and that our greatest asset will always be the rule of law. That is why sometimes it is necessary for us politicians to remind those with less visible power that ensuring freedom and the safety of our citizens must not come at the ultimate price of sacrificing democracy. But it might also be worth some people in this room remembering who the real enemy is and where it is, and that when we deal with allies and when we want answers and the truth, that friends listen most when you talk and not when you shout. Thank you, President.
Thank you very much. And now colleague Pasca on behalf of the EFD for 1 minute.
Thank you very much. Dear Commissioner, I am disgusted by the leaks about the secret PRISM program of the NSA. The agency since 2007 has been harvesting information and assessing information on our citizens, assessing all electronic communication passing through American channels. This shows that they are violating the privacy of our citizens and our rights. We must not admit this spying on European citizens. Illegal monitoring of European citizens is illegal in the EU and in the US. That's why American companies which have allowed access to this type of data to the US government, they have violated EU legislation. And we have to investigate this issue, and we have to adopt the same measures and sanctions against these companies which we apply to others who violate our laws. The paranoid behavior of our American partners is regrettable.
Now I will give the floor to colleague Vergia for 1 minute 30.
Merci, Madame la
Thank you, Madam President. Hearing you speak, Commissioner, I feel inclined to ask whether you're trying to take the rise. And I know it should have been Mrs. Redding here, but I've got to say there's nothing new under the sun across the Atlantic. The British press's revelations on PRISM merely confirm the fact that all of us, apart from a small handful, have been denouncing for some time regarding violations of human rights in the United States. In May 2010, the President told us himself how well the US Constitution protected US citizens' rights. Well, doubts have increased in recent days. Thanks to Snowden, we know that the NSA has direct access to the servers of at least 9 major internet companies. Now, they defend themselves with saying, oh, we didn't know about this, or we examine requests very carefully. Well, the source of greatest concern to us is something said by President Obama himself. And this isn't a confession. He said this quite coldly. He said internet surveillance does not apply to US citizens or people living on US territory. A judge has to authorize surveillance of citizens of those countries. So US legislation has clearly been violated. We have proof here that anybody else can be put under surveillance freely. And this is what we've been saying for months. European citizens do not enjoy the same rights as US citizens. Data is being gathered in bulk without any way of appealing this. And Europol keep confirming this. We can't anymore allow our negotiators to come back having achieved absolutely nothing. We reject ACTA because we want our citizens in Europe to have their data protected. This situation has been going on far too long. Let's bring an end to all this hypocrisy. The evidence of the facts is perfectly clear. We must make sure that US intelligence agencies respect the privacy rights of European citizens. Thank you. The next speaker has for 1 minute.
President, ladies and gentlemen, what would you say if a worker from the US Secret Services was watching you night and day, tapping your data and recording it? You wouldn't be happy with that, but 24 hours a day, that's what they're doing with internet traffic of millions of people. This House is responsible for the protection of fundamental rights. This program breaches human basic rights. What are we going to do? when it came to SWIFT and the PNR, we were taken for a ride by the US authorities. That cannot be. It's time that we grasp the nettle here, that we lived up to our responsibilities and put our minds to ending the programme. We should instigate an inquiry to see what legal implications arise from the programme, what European secret services have benefited from the data. Europol, for example. And finally, we should have US representatives invited to this House to be accountable to it. The way we're going now is just leading away from free democracy.
Ευχαριστώ πολύ, κύριε Ehrenhauser. And finally, I will give the floor to Commissioner Borg for his concluding remarks.
Thank you very much, Madam President. And the Commission, I must say, shares the European Parliament's concerns on this PRISM scandal, and I shall inform Vice President Reding of our discussion today. I must also state that Mrs. Reding will address the LIBE Committee on the 19th of June, which means that she will not only discuss and refer with the LIBE Committee on the developments which will take place until that day, but will also refer to the Committee on her negotiations and her meetings in Dublin next Friday. In fact, she will raise our shared concerns at the ministerial meeting next Friday in Dublin, and will also request clarifications from United States Attorney General Holder. This was a good debate, Madam President, even though short. And of course, there were two trends of thought which are not contradictory to each other. One of them is that we should clarify things with the United States and make it clear that whenever a European citizen information is concerned, European rules should apply, and that we are not happy with the level of protection of data information from the United States, in particular, even if you read, as Mr. Moraes said, The Guardian. There is a reference by the whistleblower to the facility with which information could be accessed by the very person who has leaked this information. In fact, he said the government has granted, he's referring to the US government, the government has granted itself power it is not entitled to. There is no public oversight. The result is people like myself have the latitude to go further than they are allowed to. So we are entitled to ask questions in the next ministerial summit on whether this has been done as regards European citizens. At the same time, I appreciate Mr. Kirkhope's remarks that let us not forget who the enemy is. And I can comment as a former Minister of Interior for 10 years. What would the fight against organised crime and terrorism be without the collection of proper intelligence? But the frustration of any law enforcement agency is, it should not be a frustration, but it is considered to be so, that while terrorists and organised crime have no rules to go by, law enforcement agencies in a democratic country ruled by rule of law cannot use anything but the gloves of law in order to fight terrorism. Which is why I appreciate the comments of those, including Mr. Weber and others, who have said we have a special relationship with our US partners, we have solved important investigations regarding prevention of terrorism through shared information with our special partnership, but no one should use this special relationship not to abide by the law and not to abide by international standards. So this is the fine balancing act of retaining this partnership. But because there is a partnership, it entails not only rights, but deeper obligations. Because if the relationship is special, then the obligations should be special as well, and no one should be taken for granted. So I appreciate also Madam in 't Veld's comments on these issues, bearing in mind also what Mr Kirkhope said about who the proper enemy is. And I would like also to recall that in the context of the proposal for a reform of data protection in Europe, and I appreciate the positive comments which have been made by different members as to the importance of adopting this new package proposed by Madam Reding, the Commission has made it clear that the extraterritorial application of laws by third countries may be in breach of international law, and the reform establishes legal channels that should be used. The Commission is ready to consider any improvements the European Parliament would consider necessary in this respect. That is why we need to work together for a swift adoption of the package that some in the Member States would like to see delayed. It is our common interest to work hand in hand in that direction, the more so in view of these recent developments. Thank you very much.
Thank you very much, Commissioner Borg. Κυρίες και κύριοι συνάδελφοι, το επόμενο σημείο στην ημερήσια διάταξη.
Colleagues, the next item on our agenda is our colleague Ms Costello's report on the Fund for European Aid to the Most Deprived. I shall give the rapporteur the floor.
Buenos días, queridos colegas. El punto siguiente.
Good morning, colleagues. The next item on our agenda.
Colega, la señora Costa.
Is our colleague Ms Costello's report on the Fund for European Aid to the Most Deprived. A very important issue, undoubtedly. Millions of citizens are following this issue with great interest. So I shall give our colleague Emma Costello the floor for 4 minutes to present her report.
La palabra, señora Costello.
Thank you, Mr. President. Commissioner, members, this proposal is presented against the backdrop of rising poverty and deprivation across Europe as a result of the crisis. There are almost 120 million Europeans, or a quarter of our total population, at risk of poverty or social exclusion. Over 40 million suffer from extreme material deprivation. This means that they are unable to put a basic meal on the table every other day. Almost 6 million children do not have 2 pairs of shoes. Over 4 million people are homeless. Since 1987, the food distribution programme has been an important support for organisations in direct contact with people at the margins of society. 18 million people across 19 member states are benefiting from this programme this year. Ending the food distribution programme next December without a replacement European programme would pose a direct threat to food aid programmes in many member states. The proposal that we are considering here today envisages European support for national schemes that address